Alrighty, this is part three, y'all. Let's I'm trying to get this lined up a little bit. There we go. Let's proceed forward.
I've gone to an arraignment, and I was curious how, say you were to get traffic infractions put upon you. Would you go to an arraignment? Would you send flurry of motions? What's your method that you would
If
use?
it's an infraction, it's civil. There should never be an arraignment in a civil proceeding. Arraignments are reserved strictly for criminal proceedings.
So it wasn't there. I do have the obstruction of a peace officer charge. I have an obstruction of a peace officer charge.
Right, that's criminal.
Right, so that's
went to an arraignment for that charge.
Correct. So
So again, we're going to go back into what? Rebuttals.
And then the other charges were attached to it. So how? So some people say sign nothing, don't say anything, just like show up there. Like, since you're saying the state national way isn't the way to go, what? Because some people will say I'm the agent of the ens legis, yada yada. What's the way that you go about it?
Well, again, what is the elements of the obstruction charge? What must happen in order to commit the crime?
Right. Well, it says there must be a physical. This was in state of Nebraska. There's a physical. It says it has to be physically challenging the officer, or there has to be threat of violence used against the officer, which I did not do either. So.
Either of those elements true?
No.
Then how are they going to prove it?
Exactly.
So, I mean, my plan is to flip it to make them prove that I did what they say they did.
No. The burden is already on them to prove it. Not for you to disprove it, but for them to prove it.
Yep.
That's the beauty of the criminal protections. Right. You have no duty to do anything except sit on your thumb and rotate and shut the fuck up. That's it. Everything else is on them. So how are they going to prove it? And how do you show that they didn't prove it when you do your cross? See, this is where most people fuck up in court. They don't learn how to do cross. And when they do a cross, they do it completely wrong, and they do it in a way that's not at all fucking relevant to what has to be proven.
Now, that's good. I would like you to go into this just a little bit more because we've been working on hypotheticals in relation to cross.
You are the officer, okay, in your case for this charge, and you're on the stand. The prosecution has just gotten you to provide all your testimony about what occurred, except for the testimony involving the two elements we just discussed, the physical interference or the threat of violence, right? They're not going to elicit testimony that happened unless the officer is willing to commit aggravated perjury on the stand and get caught.
See, that's the key point right there, y'all. Listen very carefully when you are actually in court. That attorney is actually protecting the officers by words that kind of go behind him, around him, and you are led to believe that the prosecutor is asking legit questions. But you got to do your research. You got to pay attention to the trickery of words they're using.
Right. Especially if there's body cam video showing what he just testified to is false. Now, is there body cam video?
I filed a FOIA request and they denied it, and we are sending FOIA request number 2.
Actually, are they denying it because they say they don't intend to use it as evidence?
No, they're signing some other things. And what we did is we hit really hard in doing some more research in relation to the federal applications, in relation to the restrictions in which the FOIA has upon them already due to the fact that they receive federal funding. And I think after this next one, they're coming up out of it.
Okay, but here's the problem with doing it FOIA versus discovery. Okay,
they said that they would provide it via discovery. So just for reference.
The rule is in a criminal case, you may not use FOIA to obtain evidence that is best suited to be obtained through discovery, which this is. Okay?
Okay.
So you file a motion for discovery and you put in everything you want them to produce.
Okay.
And you make the court issue an order requiring them to produce that, or making a ruling as to why they will not be required to produce.
Yeah, so should it be extra, like, should we put in a good amount? Almost so much that they're unable to... Okay.
You ask for everything you believe you need, or that is related to the thing you believe you need.
Good.
Whether the state believes that it's exculpatory, or they're going to use it or not.
Perfect.
You want it.
That being said, even in discovery, Texas got a statute that basically said for pro se's, the attorneys don't have to give this out and all that kind of stuff. So it's always good to record them, so that way you can go through there faster through your own recording, providing you get to keep it. All right, and that way you can start instantly of your rebuttal. Okay, start filling it out. You still want their documents to use in court because it's actually a more inherent standing due to it's their product that the officer is using.
But make sure that what you're asking for is relevant, because if it's not, the judge is going to deny it.
Okay, perfect. Thank you for that clarification.
So,
Wait, let me finish. Once you get that evidence, you can then review it, as is your right, and use that to basically impeach the witness if the witness lies on the stand. Okay? So this goes back to our cross-examination. You're going to play the part of the cop. Direct examination by the prosecution is just concluded. It is now your turn to cross-examination. Does anyone know the first rule of cross-examination as a novice in a courtroom?
Tell me.
The first rule: only ask leading questions. Why? A leading question is what allows you to put words in the witness's mouth and force them to admit to them. The second rule of cross-examination.
So, if you go watch courtrooms, be particular close of how these attorneys are doing with the witnesses, the words they are using to extract the words out of the witness. I mean, that there is just Roman civil law process, but it's what we're using.
As a pro se or a novice is to never ask a question you don't know the fucking answer to. And the third rule of cross-examination, whether you're a novice or an expert, is unless you know exactly the answer you're going to get, you never, ever ask a witness why they did something.
Predator generators give you the power to do more for less.
I got a piece of candy in my mouth, so it's going to be So, word of advice, when you get chances, watch these attorneys with a lawyer upon another lawyer.